Hello and welcome to Great Leap Forward, part of Virtual Patent Gateway's PTAB Practitioner series, hosted by Virtual Patent Gateway founder Ashley Chung. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Joining us today is Michelle Aspen. Michelle is the Senior Patent Counsel at Unified Patents and has been a patent litigator for 5 years and focuses primarily on PTAB trials and appeals with Unified Patents. This webinar will be recorded for future use, and we've applied for 1 hour Virginia CLE. Ashley will notify you when it is approved. There will be a short Q&A at the end of the presentation, and you're welcome to have your camera on for today's session. And with that, I'll hand things over to Michelle.
Good morning, all. Thank you for joining Great Leap Forward, Overview and Strategies for the Patent and Trademarks Office's Engagement Initiative for Junior Attorneys. Going to slide 2, we have 4 marks on our agenda today. First, I want to tell you about what LEAP is, how it accomplishes its goals, and who is eligible for it. Second, I want to talk about procedure, how you use LEAP and take advantage of its offers. And third, strategies, how to use LEAP to your advantage. Finally, LEAP is not a crutch, and so I did want to talk about oral argument and preparation so that you know how to prepare for oral arguments. So jumping to slide 4 as part of the introduction, LEAP stands for Legal Experience and Advancement Program, and there are 2 main goals. First, to provide training to less experienced attorneys and patent agents practicing before the PTAB. Second, to increase the opportunities that these attorneys might not have otherwise had to gain practical moot experience. And so put another way, LEAP endeavors to break this vicious cycle of junior attorneys never being able to present oral arguments because every client wants someone who already has experience doing so, and you can't get experience without having experience. And this is an issue near and dear to my own heart because I've been the junior counsel who was closest to the case, but didn't get to argue any of the issues because of a lack of experience in presenting before. I didn't have my first argument before a tribunal until I'd been working for about 3 years, almost 4 years. This isn't because my superiors didn't think I could or that they didn't want me to, but because 1, you need to have client approval for junior attorneys to represent them. And 2, the opportunities have become more and more rare as cases settle quickly and we move to a remote format, obviating the need to have hearings in the first place. So for example, I had a colleague who hadn't had a single argument in 7 years of practice. And who knows, maybe something like LEAP would have created that opportunity for him. So going on to slide 5, there are a few ways LEAP accomplishes its goal of training younger attorneys and incentivizing, giving them opportunities. So for training, experienced administrative patent judges, or APJs, personally provide webinars and mock arguments to junior counsel. These are the PTAB judges that will be hearing actual arguments. So this gives junior counsel practical training to improve their advocacy skills. And actually these training webinars are useful to veteran attorneys as well, as it shows common mistakes that they might make. To accomplish the goal of giving younger counsel more opportunities, the PTAB dangles a carrot to law firms and clients. Parties with LEAP counsel get more time, and senior counsel doesn't have to completely give up control. They can still guide the junior attorney by splitting time and interjecting to help with questions. So using a climbing analogy, you're not leaving counsel to free solo. You can help belay them up. So going to slide 6, who is eligible for LEAP? There are only 2 requirements. One, they need to have less than 3 oral arguments before federal tribunal. It appears that state courts don't count, but federal district courts, appeals courts, the ITC, and of course the PTAB do count toward this number 3. And then second, less than 7 years experience as a licensed attorney or patent agent. It does not matter if the lead counsel is lead counsel or not. Lead counsel can be lead counsel, but lead counsel does not need to be lead counsel. So going on to slide 8, we'll talk a little bit about procedure. The first step is that you need to adhere to the federal regulations. And so there are 3 things that you need to do. One, you need to update your mandatory notices. If your lead counsel isn't already listed, they need to enter an appearance. Second, you have to update your power of attorney. Lead counsel can't represent you without permission. They're still counsel. In a lot of cases, a customer number or firm name is listed on the power of attorney, in which case you don't need to update it. But if not, then you do need to update it to name that junior counsel and get your client's sign off. Third, if the junior attorney is not admitted to the patent bar, you may need to file pro hoc vice admission for them so that they can represent your client. The next step is very simple. You just need to email a form to the PTAB. It used to be that you'd have to file it and email it, but they clarified that you just email it and then the panel may instruct you to file. They say at least 5 days before the hearing, but I think waiting until 5 days before the hearing is a little late, especially if it's a remote hearing, since that's around the time the junior attorney would test their setup with the board's IT department. I have typically included a footnote in my oral hearing request, and that gives the board the heads up that we will be applying for lead counsel admission. And then I apply around the time we exchange demonstratives, or even earlier if we decide to request a pre-hearing conference. It's not a motion. You don't need prior authorization. You just need to email the board at this email and the process will get started. On slide 9, we have an example of the verification form and request. This is the combined form. You can use 2 separate forms, but the website's pretty explicit that they prefer using the combined form, one for verification, one for request. I would recommend also indicating in the email to the PTAB what you're specifically requesting. How much time do you want counsel to be able to interject? And in that sense, it may make sense to have a pre-hearing conference if you only want to designate 15 minutes specifically for the lead counsel and give the rest to a co-counsel. And I provided the link to where this form is located. So moving on to strategies. There are a couple of decision points you'll have to make when you use lead counsel. And one point is whether you split time with the junior counsel or whether you let the lead attorney handle the entire argument. In my practice, I handled the whole argument as a lead counsel, and then you just get the extra time. I find that that's really helpful because the junior attorney may be the closest to the case and it won't interrupt the flow of the argument, and it gives the board less things to have to manage. And the senior attorney may still assist even if you use an all lead oral argument. But if you do split times, there's a couple of decision points you have to make. First, my recommendation would be to have the lead practitioner go over discrete issues. So either a claim construction issue, a motivation to combine issue, priority issues, maybe a specific ground like the secondary ground. Regardless of how you split the time, it should be a genuine split of the time. You don't want to signal to the board that you're giving the lead practitioner a loser argument or a throwaway that doesn't really matter to the case. As an extreme example, the board isn't going to let you get away with taking an extra 15 minutes just for a lead practitioner to present the party names and introduce co-counsel. they need to argue an actual issue in the case. I also wouldn't recommend having a lead practitioner simply reiterate points already made by the previous attorney. This should not be treated like a practice moot. It is still a real oral argument. So the lead practitioner should touch on different issues from lead counsel. Going on to slide 12. The other issues that you'll need to discuss ahead of time are how you'll handle rebuttal. You'll need to reserve that time before you start the argument. Obviously, if lead counsel is handling the entire argument, they probably would handle rebuttal as well, although lead counsel can interject and take over for rebuttal if they so choose. But if you're splitting time, you'll need to decide who is rebutting. Will it just be lead counsel, even for the lead practitioner's issue, or will you split the rebuttal time as well? One way to do this is to give the lead practitioner 15 minutes, and whatever they don't use of their 15 minutes, they reserve for their own rebuttal. This should be clear to the judges that this is how you want to arrange it, as they will be keeping time. In my experience, the judges have been really good at keeping time. The other things that you need to manage ahead of time is how managing counsel will assist. If they do plan to assist, you should practice this in your practice moots before the oral argument. And you should identify what circumstances in which you might assist. So maybe it would be a particular kind of question. Maybe it would only be if the judge asks a question for the part of the argument that lead counsel is planning to handle, and they don't want to put the lead counsel on the spot for an issue they didn't prepare for. You could also have the lead counsel or backup counsel help with record citations. Regardless, it should be polite, and more importantly, it should be an assisting interruption. It's not a correction for minor wording or just, oh, they messed up and I'm going to take over the argument now. Again, you have to stick to being genuine for this argument. And my recommendation would be just don't. If interrupting has a really good chance of messing with the junior counsel's process and flow. And it could also signal an inconsistency in your positions to the judges that they might not have otherwise noticed. I think the more appropriate thing for a lead counsel who's sitting this one out to do would be to take notes and provide those notes to the lead attorney to correct things during rebuttal on their own. So interruptions should really only be used as a last resort, in my opinion. So the last thing I want to talk about is preparation for the oral argument. Just because you're lead counsel does not mean that you can use this as an opportunity to take it easy. You still need to be professional and prepare. They are still treating this as your client's actual oral argument. So this quote is often attributed to a speech by President Eisenhower in 1957. However, it's apparently a variation of a common military adage. That being said, it's applicable to more than just military strategy. During arguments, you're going to be interrupted, and you're going to be knocked off course by questions you did not expect. You have no idea how hot your panel will be or how sympathetic they will be to your case. But if you prepare well enough, even if you find yourself going into new territory, you should be able to steer your way back to the course you mapped for yourself. And so going to slide 15, the first step is preparing your demonstratives. This is where your argument begins. For every slide you prepare, you should have something to say. My practice is to write my script in the PowerPoint slide notes section for each slide I prepare for. That way, as I draft the slide, I force myself to consider what I'm trying to say with the slide, and then I can double check that the slide presents what I'm trying to say. And I'm not trying to use any filler slides that actually are irrelevant. The only exception would be when I am collecting case law sites. Sometimes I throw this slide in there for the judges to have them, but APJs are attorneys, they know the law, and you don't need to actually give them the case law and tell them about it. That's just convenient for them to copy and paste in their final written decision, should they agree with you. Every slide will have to have citations to the record. If you just cite it on the slide, which is usually what the oral hearing order requires, you'll avoid the question, counsel, where is this in the record? Judges rightfully care about that. The hearing is not the place for new arguments. And it's always easier to include these as you begin drafting the demonstratives and just cite them in a smaller font towards the bottom of the slide. Finally, every counsel needs to prepare for how they're going to rebut. And the script rule applies to rebuttals as well. I always recommend moving slides just for rebuttal to the very end, so they're not interrupting the flow, but sometimes you can strategically put them in the middle where they also apply to certain points of your argument. Most of the time, you know what the other side is going to say because they already said it in their briefs, and you should have a 1 or 2 page outline of that brief summarizing the major points. Your rebuttal slides go to these issues. And again, write a script here too, but note that you might not end up using it. On to slide 16, proofreading the demonstratives. Ideally, you'll have 3 levels of proofing on your case. First, you as the presenter and drafter should be reviewing it over and over again, and you should be sleeping on it between proofreads. You should finish your demonstratives at least a couple of days before they're due so that you and others have a chance for a low pressure proofread with a fresh pair of eyes. Things happen and sometimes you don't have that, in which case I recommend having your co-counsel be lending a hand here. This is the second level. They can help you decide if the substance is presenting what you actually want it to say. Sometimes you have things in your head that aren't consistent with what's actually pictured on the slide. Third is somebody who is very distant from the case, who's taking a 30,000-foot view, and their main purpose is to review for aesthetics and minor typos. Many firms don't have the resources for 3 levels, and that's okay, use what you have, but if you can get that 30,000-foot view, you'll more likely catch the things that are less relevant to the substance of the argument and more relevant to the form of the demonstratives. So there are 6 things that you should check. And so there should be 6 proofreads. The first 2 are global. First, do the demonstratives comply with the rules? And that includes the oral hearing order, which may be specific to the judges that you'll have. For example, they'll typically instruct you on how you need to file it, how you include record citations, and a footer that identifies this as demonstratives exhibits, not evidence. The trial practice guide and the scheduling order, in addition to the regulations, are other places where you need to check for rule compliance. Second, did you hit all of the issues in the dispute? All of the other side's arguments. This is what I'm calling substantive completion. The third one is obvious, but you need to check for typos. And it's kind of surprising, but some people don't remember that PowerPoint also has a word check, and you should use the PowerPoint spell check. Don't rely solely on that, still review it, but it's a useful tool. Fourth, citations to the record. It's often useful to have a 3rd level reviewer help with this. Just check to see that all of the citations line up to what's being shown on the slide. Finally, consistency. And this is an aesthetic thing, but I typically use screenshots for patent text and a serif font for quotes from the record. It doesn't really matter what you do as long as you're consistent. And then finally, general aesthetics and readability. Do you have enough white space in the slide, or is it really busy? Have you included transition markers in the presentation to guide your viewer? I do think having some slides with a lot of text is sometimes unavoidable in the context of PTAB trials, because judges need to be able to find the language you're citing and have that surrounding context. But in those cases, it's really important that you have a consistent means of emphasis for every slide in which you have a lot of text. Finally, practicing, well, not finally, but on slide 17, I talk about practicing oral arguments. And we have a lot of technology at our disposal. And before you work with a senior counsel, you need to make sure that you like how you yourself sounds. So before your first moot, record your presentation and listen back. It can be eye-opening and cringe-inducing, but this has three purposes. First, you can time yourself. You want to leave about 15 to 20% of your time for the main part of the argument, not including the rebuttal time, for questions. So if you had 45 minutes for the entire argument and are planning on reserving 10 minutes for rebuttal, you'll try to create a buffer of about 5 to 7 minutes. You could also record yourself asking and answering questions that you prepared in advance that you expect the board to ask based on either the institution decision or what the patent owner said in the SIR reply. You probably won't need 5 to 7 minutes to answer questions, but it's better to have it and not need it than the other way around. If I am way over time on my first moot, I will often re-record myself with a lap timer, or I'll ask somebody else to record me with a lap timer to hit the lap button every time you switch slides. And that way you can see which slides are the problem slides, and it will help you decide where you can cut down on here and there. The second use, so the first use is to help you manage your time. The second use for recording yourself is to hear how you speak. Some people trail off at the end of a sentence. I had a bad habit and still have this habit and have to work on it. But my bad habit is starting to answer questions with the word so or the phrase I mean as a filler. If you sound like you're running out of breath, it's probably because the script has a sentence that's too long. You need to include breaks where you can breathe. Sounding professional is important, and sounding confident will make you feel confident. So recording yourself will help you get closer to that goal. Finally, recording yourself will help you find a flow. You're going to go through your slides, pretending to be a judge as you listen to yourself. Are you seeing what you're recording? Did the recording make it clear what slide you were addressing? On here, you should try to be as objective as possible, and mooting will help with flow, but this is not something that you should leave to a backup counsel to help you with. You should know yourself whether your slides are matching what you're saying. Finally, and this will likely happen naturally after you've prepared a million times, but make sure you need to make sure you remember where everything is located in your slide deck. A judge may ask you a question that requires you to jump ahead and go back, and you want that to happen very quickly. You don't want it to take 20 seconds even to go to the correct slide to answer a question or to get back to where you were talking about. On slide 18, mooting. Now, here, I strongly recommend using the PTAB's mock trial tools. They will help you work on your presentation. They will give you live feedback from actual PTAB judges, and it doesn't take that long to prepare for. But when it comes to your actual oral argument, mooting is a valuable tool. This is where you have one or two people pretending to be a judge and asking you questions as you go through the presentation at least one time. You should prepare the hardest questions for your presenters to ask, and you should also have prepared your answers to those questions. But it will be nice to practice those questions in the context of someone interrupting you, because that's how it will be at trial. Again, time yourself to see how you do when it's more live answering questions, because it might take longer than when you pretended to interrupt yourself in your first recording. Mock judges should also ask new questions as well to try to knock you off your track. It doesn't need to be a really hard question. You can still have mock judges who don't know the case that well asking you questions. Sometimes they're actually going to ask the better questions, because usually one PTAB judge might know a lot more about the case than the other two. So it's useful to have somebody who's a little farther away from the case asking questions. And if they are genuine or silly, that's okay. That will help you work on getting yourself back on track. Practice pausing for a few seconds to make sure that you've understood the question, because you need to understand the question that's asked. And that may be obvious, but it's actually sometimes a little bit harder, because a question can have a couple of different compounds, and it can sometimes the judge is kind of using you as a soundboard as they work through an issue, and you need to help them understand the material from your perspective. But most of all, you need to understand where they may be getting lost before you can answer that question. Finally, it's useful that they ask questions that test your knowledge of the record and also the demonstratives themselves. You want to simulate having to flip them back and forth between slides. In this regard, it's useful to give your mooter an outline of the various argument the other side has made and your responses. PTAB judges are not going to go easy on you if they see a weakness in your client's position just because you're a leap presenter. You need to be prepared for the hard questions, and you need to know your stuff. And this is something you're required to be competent for your client. This isn't a practice moot. You need to treat it like the real thing. I recommend going through the whole presentation with at least one moot, but it's usually better to do 2 or 3. Okay. Are there any questions regarding LEAP, the procedure, the substance, how to take advantage of its resources?
I actually do have a question.
Sure.
So as lead attorneys, usually because of the level of experience, and now you have this big chance of presenting before the PTAB board. So how does one prepare, for example, on the day of? What are some of the practical tips or, kind of helpful tips do you have for young attorneys who's now getting this big break and prepare their mindset on the day of?
So I think mindset wise, the big thing to take away is don't take it for granted. Not a lot of jurisdictions have something like LEAP, and the PTAB has given you a lot of resources to take advantage of this opportunity. I think the District of Delaware has something similar in which they'll have a hearing they otherwise would not have had if it means that a junior attorney will be the one arguing, and you just have to ask the magistrate judge in advance, hey, can we treat this like a hearing? I'd like to give an attorney I'm training some experience. Here, the way to get in the right mindset is to realize that you are representing your client. This is a real thing that you're doing. And if you mess it up, you can mess up your client's case. A good lead attorney won't let that happen, of course. If they have a training attorney that doesn't take it seriously enough, then why did you hire them? But the other thing is maybe you give them something that's a little bit easier. What I've seen some counsel do is given their leap attorney one of the weaker arguments. But I think that kind of is throwing your junior counsel under the bus. And so in addition to getting the junior counsel in the right mindset, a lead counsel needs to be in the right mindset. You want to give your lead counsel the winning argument, something that they can't fail. And that way they get practice and build confidence doing something that they know is right.
Now, one other thing is that I'm not sure that you are aware, but how are the, in terms of the LEAP program, how are the, how well represented are women? Do you know like the composition between like male versus female attorneys who actually take advantage of the LEAP program?
I don't know those statistics, actually. I think it wouldn't surprise me if it's a little bit higher percentage female if I had to speculate, but it actually could be kind of even, representative of the fact that it's evening out in the percentage of counsel. I would hope that it's relatively even, but I don't know. I'd be speculating.
Yeah, I mean, I'm not sure there's a lot of statistics out there. I think that sometimes we will see stats that talk about women are still generally underrepresented in the PTAB quarters, and which is one of the reasons why we really want to promote all the women attorneys who actually wanted to get into the space and practicing, and also just really women empowering other women who succeed in this space. So I think that's one of the reasons why I really wanted to. I've always been really fascinated about the LEAP program, and so just
Well, with women empowerment, I do think that's a unknowable goal, but I do want to emphasize that LEAP is good for everybody. It's good for clients because the counsel you're hiring, they're going to retire soon. You do want someone to take up the mantle. And also your lead counsel is probably going to be a little bit cheaper than a partner who's arguing a case. So clients are motivated to use LEAP. But my friend who was faced with the lack of experience for 7 years, he was male too. I think that LEAP is less just women empowerment and more, let's hand the reins over to the next generation of counsel. Attorneys are retiring later and later compared to what they used to. And you can get up to 35, 40 without ever having an argument. And that's kind of scary to be at the middle of your career and you've never gotten to do anything substantive. So I think that this is also younger attorney empowerment because law is very much still an apprenticeship style career. And if your master won't hand over the reins, then apprentices can never graduate out of being junior attorneys.
Yeah, one other thing is that I've actually been in the legal industry for a long time, so I've seen a lot of young attorneys, aspiring attorneys, that they are like the people that were really just working around the clock, and then the lead counsel would just go in there in traditional sense. They'll go in there and say, okay, brief me on all the arguments, and then so I could just go and do the presentation. A lot of it, like you said, is client's dictation because they don't want to take that risk. So I think this particular opportunity is really great. And it's almost seemed to have, well, it kind of, I wouldn't say that it's level the playing field, but at least it gives a little bit of incentive. I think overall, the legal industry is still it runs on still a very finite mindset. So there's even with the LEAP, I think that there's still quite a bit of a scarcity mindset in terms of the competing that opportunity. How do you feel about that?
I think you're right, but I will say that the fact that LEAP exists indicates a more progressive mindset in this regard than might be in other fields of the law. Because again, I'm not aware of anything quite like this. outside of the patent bar. And, you know, if we go up to slide 5 again, all of these incentives were developed by the PTAB, and the webinars, the mock arguments, all of that, those are things that tools that you can show to your client to say, yeah, they're ready. They've been doing the training. They've done live arguments. They've done a good job. We've mooted them to death. They can do this. And so the incentive is not just to the firms, although they may be incentivized, it's also to the clients to get their extra 15 minutes and also to use the counsel that's closer to the case. One of the reasons LEAP was created, though, was not just to benefit the junior attorneys. It was also created because PTAB judges just really wanted the counsel who was closest to the case to argue the case. Because when they have questions about what the record says, they don't want to hear, I can look into that and get back to you on rebuttal. Very often a junior attorney has already scribbled it down on a post-it note to give to counsel when they sit down again. And judges are looking at this like, well, why aren't they presenting? They know where it is in the record. They know what the record says. Why are you doing this 15 minutes of preparation and presenting to me? It just makes this whole hearing kind of pointless. So it's not just clients, it's not just firms, it's not just the junior attorneys, it's also the judges themselves who want the counsel who's closest to the case to argue the case. And this is a little bit of a nudge to all of those other entities to make that happen.
Well, thank you, Michelle. I really do appreciate you taking the time to kind of share your knowledge and expertise on the LEAP program. And does anyone on the floor, does anyone in the audience that have any questions? Now's the time to ask. Well, I guess you covered the topics perfectly.
Well, you can always reach out to me, Michelle at unifiedpatents.com. And I'm happy to talk about LEAP. Again, it's an issue that's near and dear to my heart. I really appreciate that the PTAB has done this. And I think lots of people can benefit from its flexibility and also the resources it provides.
Well, thank you.
Thank you, Ashley, and thank you, Virtual Patent Gateway, for giving me this platform to present.